Hey guys, it's Jacob Blizzard again. I'm a board-certified criminal law and criminal appeal specialist attorney, and today I want to continue to talk to you about the 2255 motion or writ to vacate a judgment for federal prisoners. And so we're going to talk today about ineffective assistance of counsel, and I want to talk to you today specifically about in the context of trial, and then I also want to touch on the idea of what you really need to be thinking about when you're drafting that 2255 motion or writ. So first off, not everybody has a trial. Some people just have pre-trial, some people have sentencing. In the trial process, there's a lot going on. Lawyers are picking juries, they're making opening statements, they're preparing directs, they're putting on exhibits, they're cross-examining witnesses, they're objecting to jury instructions, they're proposing jury instructions, they're giving closing arguments. They're doing a lot of things, okay? And so there's a lot of things that have the potential to go wrong, meaning that the lawyer can make mistakes. And not all mistakes amount to ineffective assistance of counsel. You'll see that time and time again through the case law. The courts of appeals are just not going to overturn a conviction because your lawyer messed up, didn't call a witness that maybe he really should have, or didn't object to some hearsay objection when it really was hearsay and it came in improperly. But still, there are errors that on their own will stand and be sufficient enough to overturn a conviction, and then there are errors that when you put them all together amount to ineffective assistance of counsel because of the element I want to talk to you about now. It's not about the errors, it's about the prejudice, okay? So what does that mean? It means that you could identify 15 errors that your trial counsel did. He didn't call the witnesses, he didn't cross-examine, he didn't object to the jury charge, he gave a crazy closing argument. And the Court of Appeals could look at it all and they could say, we find all that, yes, he made all those mistakes, but we think the evidence was overwhelming, or we think the errors were harmless. Basically, they didn't cause you any harm. It didn't affect the fact that you were found guilty. It didn't affect the fact that you were sentenced to some certain sentence. And so what you have to focus on in thinking about your 2255 is think about the prejudice. You want to tie each error or the combination of errors to the prejudice that you suffered in your case. So if your lawyer would have told you something, or he would have given you different advice about why you shouldn't testify, because he didn't tell you that if you testified and you were found guilty that you were likely going to get obstruction of justice points added to your sentence. And so that's a way you can tie directly, oh yes, well my lawyer gave me bad advice. He said I was free to testify, there was no potential bad consequences of testifying, I should get up there and testify, but then that led to me getting a harsher sentence. That could be something that you could tie specifically to it. And that's just one of hundreds or thousands of examples that you could tie an error to a bad consequence, because you had 2 points added that led to a higher sentence on the chart, and so that means that you more likely than not got bad advice which led to a longer sentence occurring in your case. So very important to think about prejudice. So as you think about what your lawyer shoulda, coulda, woulda done, if he had been a better lawyer, then you want to think about what he should have done and how that would have impacted you. And you want to lay that out in your motion. Don't just be thinking about it like, oh yes, they're going to see that this is prejudicial. No, they're not going to see. You need to tell them how. You need to lay it out in detail how it affected your trial. You know, the failure to call a witness to a shooting was ineffective assistance of counsel because that was the only witness to the shooting and the government didn't call him. And they just relied on circumstantial evidence. And this person would have exonerated me. They would have said it was a person that didn't even look like me. It was much taller, different race, wearing different clothes, you know, something like that. That's going to be the situation that you need to think about. And of course, it doesn't have to be that drastic. That obviously sounds like, oh, well, Jacob, I can't win a case unless it's a very clear-cut example like that. No, there are thousands of examples of situations where you can tie in prejudice. But that's just the mindset that you need to have when you're thinking about ineffective assistance of counsel in your case.